We're good.
Okay, yeah, you must
the Board of Zoning Appeals for the City of Cleveland for today, June 26th, 2023. Sorry about the delay. It's the first Monday after a holiday. And do you want to announce?
Would you like me to read in the preamble?
Yes, we'll start with that.
All right. In compliance with notification requirements of the city's open meeting law in section 101.021 of the Codified Ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the City Planning Department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Please note that calling users can unmute by using *6. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We've also received emails from those who have provided written comment on a particular matter. Back to you, Madam Chair.
Thank you. Would you like to call the roll?
Sure thing. Ms. Holzer?
Present.
Ms. Roca?
Present.
Ms. Faith?
I am here.
And we have had one member resign. Ms. Terry Hamilton Brown is no longer with us on the board. So today we have a quorum of 3 members. And the issue with that is that you will need a unanimous vote of the 3 members that are present today. If you do not receive the unanimous vote, the variance is essentially denied. The decision of building and housing will remain. So you have the right to request a postponement when your case is called to another date when we have new board members. We are working on it, so I think we should have new members within a month, I think, at least 30 days.
At least probably up to 4.
Right, up to 4 weeks, or up to 4 members, right?
Yes.
Yes. So for any appellant here, you wish to request a postponement out to approximately 30 days when we have a full or at least 4 members on the board. You have the right to do so. So, okay, back to you, Madam Chair.
Okay.
And I will announce the withdrawals and the postponements.
Yes, that was
We
going
do have one withdrawal this morning on calendar 23-079. This is regarding 8700 Blaine Avenue. Kingdom Builders Transitional Housing Program proposed to establish use as transitional housing program for up to 36 formerly incarcerated males. The appellant in this case has withdrawn the appeal. Therefore, there will be no testimony taken on this case.
Okay. Is that our only one?
The next one is calendar number 23-093 regarding 6605 Clark Avenue. The appellant proposed to install 8-foot tall fence in a C2 local retail business district. This one has not been withdrawn. It has been postponed to July 3rd at the request of the appellant to consolidate his 2 cases that he has pending with us.
Excellent.
So 23-93 will not be heard today. There will be no testimony taken. That has been postponed to July 3rd. And so one more announcement I should make of the printed or the posted agenda. We had notified that there were going to be calendar numbers 23-085 through 23-089 regarding addresses on West 128th Street. Greater Cleveland Habitat for Humanity proposed to erect single-family homes on the addresses that are listed on the agenda. But you may remember that we had moved those cases to June 12th.
Correct.
So we will not be taking testimony on those. Testimony has already been taken and we'll be ratifying those cases today.
Okay,
So
excellent.
that's all that we have for announcements.
That's all that
Thank
we
you.
have.
Yes.
Okay, excellent. Mr. Ruland, any council people present?
Madam Chair, I did just see Councilman Marsh is with us.
All right.
So that would be 7210 Memphis.
All right. As a courtesy to city council members, when they are present, we move their case to the top of the agenda. So Ms. Holzer, we'll start with 23-092, since we have Councilman Harsh with us.
Not a problem. Good morning, everybody. I'll wait until we scroll. Okay, perfect. Our first case is calendar number 23-092. This is at 7210 Memphis Avenue. Annie's Properties owner proposes to extend the canopy and add a new fuel pump to an existing gas station and convenience store in a C1 local retail zoning district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 3. And I apologize, Madam Chair, who is going to be doing the oath?
Excellent question. Ms. Rocco, would you like to take that?
Sure, I will try it out.
Thank you.
I'm swearing in all who are present for this case. Do you swear or affirm, or do I need to find out who's present in this case first?
Yes.
We want to call
Read it
everyone.
first and then,
Yeah, well, we need to identify the people that are present for the case.
is there anyone in the room who's present for calendar number 23-092
Or online.
or online?
Chris Harsh, Cleveland City Council,
Do
Ward
we have an
13.
appellant present for calendar number 23-092?
Yes, it looks like we have Carlton Moore. He's identified as the contact person.
Mr. Moore, are you with us?
We're also being told we can't be heard very
Or
well.
is muted if he is with us. There.
You hear me now?
Yes, okay.
Good morning, everyone.
Okay, there. All right. We're going to proceed with swearing you in then. So please raise your right hand. Ms. Roca is going to read the oath. You will reply, "I do," and state your name and your address. Do you swear
Hi,
or affirm? One moment.
One
I'm
moment,
going to read it
please.
first.
Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand and reply with, "I do," your name and your address.
I do. My name is Carlton Moore. My address is 3195 East 130th Street, Cleveland, Ohio, 44120.
Thank you.
Chris Harsh, 601 Lakeside, Cleveland.
Thank you. Madam Chair?
Thank you. All right, Mr. Moore, would you like to explain to us what you want to do?
Good morning.
Yes.
First, would you like the history of this property?
Yes, I would. Thank you.
Sorry, Mr. Moore, I'm gonna read.
Sorry,
the history.
Mr. Moore.
So this is regarding 7210 Memphis Avenue. The property was originally zoned as general retail. And then in 1971, it was changed to the current local retail business district. In our records administration office, we found that in 1928, a permit was issued to erect a gas station on this site. And then in 2015, a permit was issued to demolish a one-story structure. The most pertinent information after that point, Madam Chair, is that later in that year, in calendar 15-204, a variance was granted to construct a new gas station with convenience store. There was a condition placed on the uses that were to be made part of this overall project. The appellant agreed to not establish uses such as auto title loan stores, check cashing businesses, pawn and gold shops, cell phone stores, and marijuana paraphernalia stores, and similar businesses. There is also a revised drawing that was submitted showing that the rear of the building will be secured with a fence and a locked gates. So again, that was in calendar number 15-204, and it was ratified on October 26, 2015. That's all that I have. Thank you.
Thank you. All right. Legal standard, please.
Madam Chair, members of the board, appellant is requesting a use variance and an area variance from setback requirements of the zoning code. To obtain use variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economic or peaceful use of the property without variance, will deprive the appellant of substantial property rights, and the granting variance cannot be contrary to the purpose and intent of the zoning code. To obtain the area variance, appellant must prove that denying the request will create practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and that granting variance will not be contrary to the purpose and intent of the zoning.
Thank you. All right, Mr. Carlton, now if you would please tell us what you'd like to do.
Good morning, everyone. Can you hear me now?
Yes.
Okay, thank you very much. What we have here is an existing Shell gas station that currently have 4 pumps for dispensing gasoline at this location. And it is the owner's desire to just add 1 additional pump because of the volume of business. And by adding an additional pump, the flow in and out of the gas station and people getting their gas will be a lot smoother than what it presently is. This is a very active intersection at that location, and the desire for gasoline at good prices has dictated that the owner would feel as if we will get a better flow if we just add 1 more additional pump at this location. And that's all that we're here to do today is we have four pumps and they're adding 1 more additional pump.
Mr. Moore, so you are not the owner? Are
No,
you the property owner?
no, I am not. I am the owner's representative. I'm responsible for coordinating the drawings as well as the construction and working with N&N Services, which will be the builder for this gas station. They were the previous builder. They're coming back to add an additional pump. And I submitted an affidavit signed by the owner to represent him today at the zoning board of appeals hearing.
Thank you. That's what I was getting to. Do we have that?
Yes.
All right, great. Okay. All right. So is there anything else you want to add before I move on?
No, that's all. It's just an addition of 1 more pump. We're gasoline pump, and we're expanding the canopy to shield the person who's getting gas at this a new pump. And it will be 1 continuous canopy and just 1 more additional pump.
Councilman Harsh, do you want to speak before we hear from city planning, or do you want to wait?
I'll wait till the end. Thank you.
All right. Typically, the council people do, but I just wanted to check. Maurice?
Madam Chair, Maurice Rowland, City Planning. I will agree that it is a very busy gas station. As it happens, I happen to live in the Old Brooklyn neighborhood, probably right around the corner from this gas station, so I am aware that it's usually very busy. The pumps are often taken. I do have some concerns about adding an additional pump to what I feel is already a fairly tight site. And I also have concerns about how it will affect circulation. I personally think it will make circulation worse on the site as opposed to better. If you look at the drawing, you can see that the addition of this extra pump actually falls pretty much in the middle of where one of the egress and ingress portions of the site are. So I think that will be somewhat problematic unless that curb cut maybe were to be reduced and marked as either in or out only. So I have some major concerns about adding a pump here. I don't know that it's necessary. And I just think it will add to more congestion on the site.
So to clarify, we're looking at the extra pump that on the drawing that we're viewing is on the left. Thank you for zooming in there. All right.
So as you can see, the pump falls, and where the car would be sitting falls right in front of that door right there. Now, if we go back and look at the actual aerials and pictures, I kind of added a little piece to the existing canopy here as to where it's going to fall. There's that doorway, so you can see that it's gonna definitely impact that point of egress. Apparently, you'll be able to see it, I think, even more clear right here in this upper left-hand photograph, where you can see the door that it's going to be extending out to. And it's gonna be blocking this entrance exit.
Can you go back to plan view so we can see that curb cut? And zoom in just a tad for me, please. Yeah,
How many feet? Can we tell how many feet it's in the curb cut? Is that,
I don't know what the dimension of the curb cut is. It's not on the drawing.
it's
It looks-
30 feet. The curb cut's 30 feet.
Oh,
Yeah,
yep,
it's a-
there it is.
so it's like a double wide curb cut. And then what is our dimension from the front door to the vehicle that's in the plan there?
That we don't have.
That
would
we
be
don't
listed
have.
there.
Mr. Carlton,
Yes,
do you know, or I'm sorry, Mr. Moore, I called you Mr. Carlton.
oh, it's fine.
Okay, it happens to me a lot with my name, so I apologize, I'm sensitive to that. What is
At
the
the distance from the rear, what, if you're asking where the concrete walkway is located at, and that
Yeah.
distance from the pump, well, let me see if I can explain this here. From where the new pump, where it says new pump, from the new pump to the edge of the new concrete walkway, but it is an existing concrete walkway, that is 30 feet. Typically, a passageway for car travel is only 24. So in essence, we're 6 feet beyond that. So we have 30 feet from the edge of the new pump to where the walkway is.
What's the width of that walkway?
That walkway is a 4-foot wide walkway.
4 foot.
And likewise, from the edge of the pump to where the landscaping is, that is also 30 feet. And you only need 24 feet for cars to pass. That's typically what is done. You allocate 24 feet, but we have 30 feet. So there's adequate room for cars to enter into the pump without interfering with each other.
So, if I may jump in.
Yes, go ahead, sir.
So, I'll just say that my current understanding of the situation is that life is good on the corner of Ridge and Memphis. The gas station is well maintained, it's clean. It does do good business. I see people moving in and out. There's a pizza shop. I think everything is fine. I've never heard a complaint about the gas station. There are no existing problems that I'm aware of. So with that out there, the thing that I'm concerned about is that, first off, I'm not sure about the accuracy of this drawing that we're looking at. If you look on the overhead Google map, the current canopy ends about where the curb cut begins. But in this drawing, the canopy ends, yeah, right there. So the canopy ends about where the curb cut begins, and the additional canopy would cut well in front of the curb cut. Also, the drawing shows parking on the northern edge, and the parking is clearly on the eastern and western edge, which does impact my third note, which is that if you look at the Google Street View of this gas station right now, you can see that there is a semi parked in between the building and the gas pumps. And that semi can logistically only come in off of Memphis and head north through the parcel and then exit onto Ridge Road. And I'm not sure how that semi and that traffic exits the parcel with the existence of a new pump and canopy covering the space in between the curb cut and the building. My concern is that what we have is a good operating, happy, tranquil gas station turns into a traffic problem at the corner of a very busy street. And the cars could potentially be backed up, especially when truck traffic comes through. that no longer has a way to get in and out of the property easily.
Councilman, is that semi that you're seeing on your Google view, is that the tank truck to fill the fuel tanks?
I can't tell. No, it's a different semi. It just says Team Shed. I don't. It's the current Google Street View from September 2022. But
Okay.
it's just a demonstration that like that you can see how
Right.
that was pulled in and got out, and I'm not sure how that truck gets out because it, I'm concerned about traffic flow, and I guess my question goes back to the original threshold about showing a hardship. The gas station seems to be operating just fine. It seems to be doing well. I don't understand what the hardship is or why they need to add another pump, potentially congest a well-operating gas station.
I don't know why a tractor trailer truck is shown, or tractor trailer trucks are probably rare or don't occur often at this site. I'm not quite certain why. It is on the map, but I don't know. That's not typical of what's at this location. And one of the issues when you have a gas station like we have at this location that's doing very good business, you can alleviate the traffic congestion by adding a pump, because you have now the street, the traffic volume is dictating that they need an additional pump so that people are not waiting, and that was the purpose of adding this additional pump, to alleviate congestion on the site, so that people can, based on the traffic flow, the traffic volume coming to this, and the people wanting to get gasoline at this station, that dictated the need for the additional pump, so that people are not waiting at the pumps based on the amount of volume that this station is currently doing.
I understand that that's your argument, Mr. Moore, but
Yeah.
we've heard from city planning and we've heard from the council person. I'm gonna open it up to my board members for questions and comments at this point.
Madam Chair, just one
Yes.
additional comment, if I might.
Yes.
On the view that you're looking at right here, where the white car is on the left, there are 5 parking spaces that will go away because of this expansion of the canopy pump. And I would like to point out, having gone to this gas station before, that if you look up on the upper left-hand side where there's an ice machine, people routinely park right there in front of the store,
To load the
parallel to
ice.
building. And it just creates, and with the loss of the 5 parking spaces, I think it's going to create even more congestion, because you have people pulling right in front of the building and getting out and going inside to make a purchase. So I just think it's going to, as I said before, I think it's going to do exactly the opposite that it was intended, is, but instead of relieving congestion, I think it's going to potentially make it worse.
Okay, board?
Madam Chair and Mr. Rollins, can we go back to the drawing? Because I think the parking was, oh, I see. So the parking by that curb cut is being eliminated. That's what you were referring to?
Exactly. In front of the one set of doors.
Right.
Is parking spaces.
I don't have any further questions, Madam Chair.
Okay. Ms. Holster, anything else?
I don't have any questions either.
Okay. Mr. Moore, it's, I can understand your argument and, the rationale behind thinking that adding a pump is going to alleviate traffic in this situation. But we've had a case recently, with regard to adding pumps, and, it was not something that was approved. And in this situation, you do not have the support of city planning, nor the support of the council person. In looking at this, it was suggested by Mr. Brulin's that even changing traffic flow so that there was one clear curb cut for entrance and one for exit. Looking at this, I don't think that that would even alleviate the situation. So at this point, we're going to move to entertaining a motion.
Can I ask a question before you do your motion?
Yes.
Is it possible that I can meet with the council person and work with the city planner and to see if there is a way that we can, I haven't had a chance to sit down with them, but I would be more than willing to sit down with the city planner to see how we can make this work that would meet their satisfaction by adding this additional pump. Because I can only stress that the pump is needed. And we can eliminate some of the parking spaces here because parking, most of this is in and out very quickly. It's not long-term parking. So just as you have at the pumps, you know, you have 8 parking spaces currently for people to walk into the gas station, and you have side parking. So we probably have more parking than what's necessary when you count the parking at the pumps. So if possible, before a final decision, because I get the impression you're not going to approve this, is it possible that I can meet with the city planner and maybe come up with something that would be acceptable before the Board of Zoning Appeals?
Let me go to the councilman first and ask him if that's something that he is willing to do. It sounds like the appellant is asking for a postponement, Councilman Harsh, so that he might meet with you in the city planner for the area to see if there could be a new plan for this. Is that something you'd want to do?
So I'm at this corner all the time. There is no competition, I would add. This is the only gas station. If you want gas at the corner of Memphis and Ridge, you're gonna go ahead and pull in and wait for a pump to clear up. I haven't seen that happen a lot, though. It seems like a really well operated location. It seems like they're doing good business. I don't see a hardship. I only see congestion being added. So I would urge the board today to vote on this appeal and just deal with this one as it stands. And if the appellant wants to talk to me about a different plan later on, I'm happy to talk to him about a different plan. But I'm not going to support this one. I think it's already in good shape. I think it's a well-run place, and this is going to potentially muck that up. So I'm happy to talk about a different plan, though, at a later date. I can provide my contact information.
Okay,
Madam Chair, I just want to clarify,
yes. To Ms. Roca.
if the board votes and the variance is denied, then the appellant cannot come back to the board for the same variance. That is correct?
That is correct.
Well, Madam Chair, if
Yes.
they change the plan, it has to be a significant change though.
But if the plan that they are seeking in their new appeal or their new request, excuse me, is to put in a gas pump, then that would be res judicata.
Well, in this case, I think that it may not, because it is an area variance. I guess I would refer to Mary if she could answer that. Again, it's just the yard issues. If they were to change the plan, then I could be wrong though. But it is a use issue as well.
Right, they're two,
Expansion of a
use and area.
Right.
It's expansion of a non-conforming use.
So, yeah, I agree.
Right, substantially different. So I think that the appellant should be aware of that before we proceed. Just so he is fully informed of his choices.
point. Right. Okay.
Uh,
Mr. Morissette,
Could you explain that in layman's terms? That some of that went.
Maurice, would you like to explain, or I'm sorry, Mayor?
well, we're going to defer to our attorney, Mr. Moore, for you.
Well, once a decision is made on the plan, it would have to be, it's decided, it would have to be appealed to another body. Unless, but you could come back with something substantially different at this location.
Did you hear that, Mr. Moore? I don't know if you can.
No, I didn't hear
Yeah.
that clear.
The other body would be, they would have to go to the Court of Common Pleas. if they make a decision on this plan.
Oh, it would have to go before the Court of Common Appeal. Yes, I hear. That's the only way.
Yes, or you could withdraw it now.
If we would,
Plan.
well, I guess if we withdraw it today, does that give us an opportunity to sit down with the city planner? And I guess the councilman is saying he sees it no way, no how. So is that,
That is his stance with the current plan, and the plan would have to be, I mean, your plan would have to be radically changed.
Hmm. Woo. What is the position of the city planner? Do they feel as if it's possible that we can discuss this?
I always hate to say that we would not be willing to discuss things. And I'm not the city planner for the region. Brittany Pabon is our city planner for that area. You could potentially meet with her, but again, going back to Councilman Harsh, I mean, it really would be important to get his support as well. And if he feels that this is just a no-go situation, I'm not sure that it would be fruitful to meet with the neighborhood planner for the area. But I'm not saying that we would not be willing to meet.
Is that clear,
Um,
Mr. Moore?
Yeah, it's pretty clear. Well, let me, here's the best thing for me to do. Let me table this for today, get back to the owner and see if he would like, if he feels as if it's worth it meeting with the councilman and the city planner and coming back before. But if that's possible, I would like to table this and request that a decision is not made on this project. A final decision is not made on this project.
So
Is that-
withdraw.
So he's requesting a postponement.
Do you want a postponement, or are you withdrawing today?
I would like a postponement.
Okay,
We can give him 30 or 60 days.
let's give him at least 60.
60 days. That would be the end of August, so August 28th.
Okay.
That would be all right.
Mr. Moore, we're gonna move you to August 28th, if that's agreeable.
It is.
That gives you 2 months to see what you can do with this.
Yeah, I think that's the only thing I can do with the owner. And I'll be very honest with him. This is almost like he has a very uphill battle, to say the least.
I think honestly, since you're not the owner, the prudent thing for you to do is to discuss the situation with him.
Yeah.
So, yeah.
Yeah.
All right, so we're gonna give you August, what did we say, Liz?
28th.
28th, thank you. All right, so you're postponed to
last
August 20. Yes,
Can I get the name of the council person? I didn't hear it clearly.
Yeah, I'm not muted, right? Okay.
Yeah.
Chris, K-R-I-S, Chris with a K. Last name Harsh, H-A-R-S-H. And you can get all my phone number and email on clevelandcitycouncil.org.
Yes.
Clevelandcitycouncil.org has all my contact.
And that's Chris Hart. And what is the city planner?
Brittany Pabon, P-A-B-O-N.
Could you say that again?
Brittany Pabon, P-A-B-O-N.
Thank you very much, everyone.
okay, Mr. Moore, have a great day.
All right. Bye
All
now.
right. Bye, thank you, Councilman.
See y'all later.
Okay. Any other council people present? Maurice?
I do not see any others.
Okay, Ms. Hulser. We will go back to the top of the agenda, please.
Sounds good. Our next case is calendar number 23-083. This is at 1466 West 29th Street. Peninsula Holdings LLC owner proposes to construct a new single-family residence in a D2 local retail business district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is one. And with that, I will hand it over to Ms. Roca for the oath.
Thank you.
Do we have anyone on the call or in the room for this case, for case number 23-083?
I am here. Antonia Marinucci.
Thank you. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address.
I do. Antonia Marinucci, 4014 Whitman Avenue, Cleveland.
Is there anybody else? Okay, thank you, Madam Chair.
Thank you. Just trying to get the spelling of your last name. I can't quite see the screen. Is it Marinucci?
Yep. Marinucci.
Great, thank you. I didn't mention this, but we do have a court reporter who is not present with us. So when you're stating your name, when we're swearing you in, please be sure to speak loudly. And if you have a more unusual name, you may need to spell it so we have it clear. All right. History of the property, please.
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 2014, it was changed to local retail business. In our records administration office, we found that only in 1925, a permit was issued to erect a garage. And then in the more recent history, we found that in 2012, a permit was issued to demolish a two-story frame, two-dwelling property at the site. And that's all that I have.
What year was that?
That was 2012.
Thank you. Okay, legal standard, please.
Madam Chair, members of the board, Helen is requesting an area variance for parking requirements in zoning code. To obtain the area variance, opponent must prove that denying the request will result in unnecessary hardship, particular to the property, such that there will be no economically feasible use of the property. Without variance, the property held with substantial property rights, and they grant the variance will not be contrary to the purpose and intent of the zoning.
Thank you. All right, Ms. Marinucci, if you'd like to tell us what you'd like to do, please.
Sure. To be clear, I'm the architect on the project, and I do have an affidavit from the owner, Laura Bidwell, to represent her on this project.
All right, we have that on file.
Great. We're just proposing a single family, story and a half cottage. It's a 2-bedroom, 1-bath home. The lot is substandard in terms of its width. So the applicant did not have any desire or need to create an off-street parking space. There's not an existing curb cut, and we felt that it also was best for the nature of West 29th Street, which has a lot of street parking and a mix of residential and retail, that we not, push that and ask for a curb cut, as well as limit what we could do in terms of buildable area between setbacks and creation of a driveway if we were to add a parking space. So that is the reason behind not providing off-street parking, and that's what we're seeking relief for today.
What's your lot width?
34.5 feet.
Thank you. City planning?
Madam Chair, Maurice Rowan, City Planning, we support the variance for no parking space with this house. It's something that is consistent with the policies that the city is currently developing for parking throughout the city of Cleveland, especially in areas that are very close to well-served transit corridors, such as Detroit Road, Detroit Avenue, right down the street from this. So it's very consistent with where the city is moving with regard to parking requirements. So we recommend approval.
Great. Board, any questions or comments?
No, Madam Chair.
Hearing none, I'll entertain a motion.
Madam
I can do
Chair. Oh, go
Oh.
ahead, Nina.
Ms.
I was just
Holster's
gonna
gonna go for this one.
I was just gonna say, having heard testimony from the owner's architect, I move to approve calendar number 23-083.
Would you like to second?
Board Member Roca seconds.
Thank you. Ms. Kukla, would you like to call the roll, please?
Sure thing. Ms. Roca,
Yes.
Ms. Holzer,
Yes.
Ms. Bates.
Yes.
Calendar number 23-083 is granted. Will be ratified
Thank you.
next week, and then we will send the appellant a letter.
Thank you. Have a good day. Ms. Holzer, moving on.
Our next case is calendar number 23-084. This is at 12210 Lorraine Avenue. STS Housing LLC proposes to install approximately 100 linear feet of 8-foot high chain link fence in an actual side yard and actual rear yard in a local retail zoning district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there is one. There's also a note that landmarks approval is required. And with that, I will hand it over to Ms. Roca for the oath.
Do we have anyone on the call who is present for this case number 23-084?
We have somebody, a person here.
Oh, I'll give someone in person. Great.
You may step forward, please. Have a seat.
Hi, everyone.
Good morning.
Madam Chair, also point out that Dan Wilson is his phone base, so you probably don't.
Okay, we'll
Okay.
go with the individual on the call first. I am swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, state your name and your address.
I do. Dan Musson, 601 Lakeside Avenue, Cleveland, Ohio, 44111.
Thank you. And ma'am,
So,
you'll have to speak a little bit louder for the,
I do.
and just state your name, full name.
Tia Williams, 122 Lorraine Avenue, 12210 Lorraine Avenue, Tilburn.
Thank you. Madam Chair.
Thank you. All right. History of the property?
Thank you, Madam Chair. This property was originally zoned general retail in 1929. In 2007, it was changed to the current local retail business district. In our Records Administration Office, we found that in 1948, a permit was issued to erect a masonry store building. And in 1954, 1962, 1975, there were business sign permits issued to the property. We also see that starting in 2005, there are yearly food licenses issued to the property, ending in 2018. And there is one variance case that was made to this office, it was in calendar 20-062. In fact, this was not a variance case, it was an administrative appeal. The appellant was appealing a noise nuisance and criminal activity notice regarding tilt bar at this site. This case was ultimately withdrawn because an agreement with the city was made. And then, Madam Chair, really that's all that I got that's relevant. Thank you.
So did that come before us?
It did in 2062, in that calendar 2062. No, actually, let me check to see, did we ever take any testimony on it? We may not have.
I'm
Yeah.
not recalling that.
Yeah, I'm thinking there, I don't have all the record here. I don't have the transcripts. I believe that it's very possible that no testimony was taken.
That's what I thought.
I do see
Okay.
that it was postponed at one point for 30 days so that the appellant could work on a settlement with the
Yeah.
city, so.
So it probably didn't come before.
Right.
Okay. Not really relevant to this,
No.
but just good to know. Okay. So legal standard, please.
Madam Chair, members of the board, appellant is requesting an area variance from the requirements of zoning code. To obtain the area variance, appellant must prove that denying the request will result in an unnecessary hardship particular to the property, such that there will be no economically feasible use of the property without the variance, will deprive the appellant of substantial property rights, The granting the variance will not be contrary to the purpose and intent of the zone.
Great, thank you. Okay, I'm sorry, what was your last name again?
Williams.
Williams, thank you. All right. Okay, would you like to tell us what you'd like to do, please?
We just wanna.
Speak
up.
up, speak
I'm
up
sorry.
for the microphone.
We just wanna replace, it was already an 8-inch fence there, we just wanna replace.
Like 8-foot
Yes,
fence.
8-foot fence, yes, we just wanna put another one there
Okay,
and just replacing it, that's all, for safety purposes.
and was the one that was
Storage.
existing also chain link?
Yes.
Okay, all right, so just a replacement. Okay, city planning?
The Landmarks Commission was,
Oh, landmarks, I'm sorry. Mr. Munson, would you like to make a comment?
Yes, thank you. Landmarks is supportive of this. It's in the side and rear yard, so it shouldn't have any adverse effect to the historic district. So, yeah, so we're supportive.
Okay, excellent.
and of course, Madam Chair, City Planning concurs with the Landmarks Commission's.
Great. Questions or comments from the board? Okay, I'll entertain a motion then.
Madam Chair, upon hearing testimony today, I move to approve calendar number 23-084 at 12-210 Lorraine Avenue.
Could I have a second? Ms. Holzer?
Board Member Holzer, I second.
Great, thank you. Ms. Kukla?
Ms. Holzer,
Yes.
Ms. Roca,
Yes.
Ms. Bates.
Yes.
Calendar number 23-084 is granted. It'll be ratified next week and then we'll send you a list.
Good luck with your fence.
Thank you.
So have a good day.
You as well.
Thank you.
All right, moving on. Ms. Holzer?
Our next case is calendar number 23-069. This is at 10306 Somerset Avenue. One Call JC Mechanical LLC proposes to change the use of a 2-family residence to 3-family residence in a B1 2-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 5. This case was postponed from May 15th to allow time for the appellant to review the refiling / res judica, I can't talk this morning, judicata findings. And with that, I will hand it over to Ms. Roca for the oath.
Do we have anyone on the call for this case? Anyone in person?
We have no appellant present for calendar number 23-069. This is 10306 Somerset Avenue. Is there anyone present? Liz, do you want to try and contact them or have we heard from them?
Sure, Madam Chair.
Just send
You can have Brittany give them a call. And we could just hold it until the,
Yeah.
close to the,
Yeah.
just in case it's running late.
Okay. We are going to see if we can contact the person for that case. Should they join us, they will be moved to the end of the agenda. So we'll move on to the next case.
Our next case is calendar number 23-056. This is at 3608 East 118th Street. Anthony Dial proposes to establish use as a residential facility for 5 occupants in a B1 2-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 2. This case was postponed from May 15th and April 17th to allow time for the appellant to meet with the councilman and to acquire a petition for support from neighbors. And with that, I will hand it over to Ms. Brown, or Ms. Roca for the oath. Sorry.
It's okay. It's new. It's new procedure.
Change.
Thank you, Ms. Holzer. Do we have anyone on the call for this case? Do we have anyone in person for this case?
This is calendar number 23-056 at 3608 East 118th Street. Do we have anyone present to make testimony for this case? Liz?
As with the previous case, we will reach out to the appellant right now,
Thank
find out
you.
if there's an issue, and we'll hold it till the end.
Okay, as a courtesy to the appellant, we will try and contact them and we're going to move forward. If they become present, we will move this case to the end of the agenda. So that brings us to calendar number 23-011.
Sure. Our next case is calendar number 23-011. Crittenden Court Joint Venture LLC is appealing the decision of the Commissioner of Assessments and Licenses. Crittenden Court Joint Venture LLC, doing business as Crittenden Court Garage, appeals under the authority of Section 76-6B of the Charter of the City of Cleveland and Section 329.02D of the Cleveland Codified Ordinances from the decision of the Commissioner of Assessments and Licenses to not waive the regressive reassessment of parking tax for area residents. This case was filed by the appellant on February 27th was withdrawn by the appellant on February 27th to allow for the appellant and the city to work out an agreement. The case was reinstated as the city and the appellant could not come to an agreement. And with that, I will hand it over to Ms. Roca for the oath.
If you'd like to come to the front, please.
Bring as many chairs on it.
Excuse me, so Mr. Stevens just ran to the restroom, he'll be back in a second. I saw.
Okay. We can get these folks sworn in while we're waiting. Thank you. I
always agree to be sworn in, but as an attorney.
oh, you don't have to swear as an
Okay,
attorney.
okay.
I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand. Reply, I do. State your name and your address.
Audrey Mecklenburg, 1382 West 9th Street, Cleveland, Ohio, 44113.
Can you please spell your last name?
MECKLENBURG.
Thank you.
I do, David Bowen, 0924 Lake Avenue, Cleveland, Ohio, 44112.
Thank you.
Thomas Paris, Paras, 182 Westman Street, Cleveland, Ohio.
I do Bernard Butler, 601 Lakeside Avenue, Cleveland, Ohio, 44114.
I do, Krupa.
Can you spell your last name, please? K-R-E. Thank you. And we have one person who is going to join us in a moment. Madam Chair, would you like to wait for them or?
It's the commissioner, right?
Yes.
Yeah, we'll wait.
I still didn't get your MECLEN.
MECKLENBURG.
Okay. B-U-R-G. Thank you.
And do we have anyone else who's making testimony on behalf of the city?
Just
All right, okay. Does anyone need a break?
Yeah, well, that's a good time for us.
Okay, we're gonna take this opportunity to take a quick break since this is probably gonna last a little bit and we'll be right back.
Don't be so sure.
Oh, all right. Okay.
Mr. Cohen. Your summer haircut.
He was longer.
Yeah, one.
You did?
That's.
I did too. Tell.
Well,
Oh, no, you're not.
gotta read this. We're gonna read each
Please,
page
no.
individually.
No. I could take.
And I'm a slow reader.
Isn't this overbroad? Isn't that a term?
Are you submitting all of this for file?
If you want to. They're in your records. The city has them.
Oh, okay.
Liz, the first one. We're off, right?
I don't know, are we, we're still on, we're still recording.
We're still live, yes.
Oh. Never mind.
We want to leave.
Can you, oh, there we go.
Oh, are we
We
unmuted?
need to swear you in, sir, and if you'd like to step to the table and
You can
join
bring
the
a
party.
chair if you'd like. Are you an attorney, sir?
No.
This is the director.
Oh, I apologize.
Yeah. Just, you can pull the seat forward if you'd like and just join us up front.
You will please raise your hand. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please state or reply with I do, state your name and your address.
My name is, I do. My name is Dedrick Stevens, and I'm at 601 Lakeside, room 122.
What's your first name again? I'm sorry.
Dedrick,
Dedrick. E-D.
Dedrick.
S-T.
EPHENS.
Oh.
Great.
Thank you.
All right. We have heard testimony or history of the property.
Madam Chair, before we move
Yes,
on, just
right.
one moment. The attorneys for the appellant, Mr. Coyne, I know who you are.
Catherine
Weber. Weber?
Thank you. K or C?
K.
Thank you.
I'm sorry, Madam Chair.
It's okay. No. Good question. All right. Okay, Liz, any
This is an
history?
administrative appeal, so we will not have any history on.
Right, okay. And
Madam
Mayor?
Chair, members of the board, upon is appealing an administrative decision of the Commissioner of Assessments and Licenses. Standard of review to be applied is whether the administrative decision was illegal, arbitrary, capricious, unreasonable, or unsupported by the preponderance of substantial, reliable, and appropriate evidence. The appellant fails to meet this burden, the administrative decision must be affirmed.
all right. Okay, I assume, Mr. Coyne, you're acting as spokesperson?
Yes, thank you, Madam Chair. First of all, I want to introduce the team here. Catherine Weber is to my right. She is counsel with my firm and is representing the applicant, Crittenden Court Joint Ventures. To my left is Audrey Mecklenburg, who can answer any questions you have about operational issues with the parking facility. She represents the operator. And also Mr. Pierce and Mr. Bowen are here because they also have an interest in the Crittenden Court Joint Venture through family members in particular. Mr. Stevens here, I don't know if he wants to comment on how we got here with their interpretation of the codified ordinances first, since it was your finding and interpreting the ordinances that brought us here.
The chair to the town, we're under the impression that.
Just have to speak a little bit louder, I think.
Right.
um,
And did we get you sworn in?
I'm an attorney with this.
Oh, okay, fine.
What is your name, sir?
Vishnu Gangland.
Can you spell that?
Spell the last one. It's G-A-N-G, like the word gang, L-A-N-I, Gangland.
Thank you.
Okay, great. I think we've got all the players now. All right, took a while. It's a big team today.
Well, through the chair to the appellant, you want the commissioner to speak to his determination, or do you want to go ahead and make the case about the burden?
Well, I guess I recognize the burden. It's just that given our other meetings, there's a question about the ambiguity of the language. And I thought maybe that the commissioner can address that as to why we're here in the first place.
Well,
I will let you go ahead, because we want to go through and state the whole statement that's going back from Mr. Skinning.
so we can go through the city's stance through the chair in general and continue through. We maintain that the ordinance is not ambiguous, as was discussed during the meeting with the appellant. We're under the impression you're going to make a case. I mean, we could have it.
Okay.
Whatever.
If that's your position, we can do that. I just thought since the division made the finding, but we'll go ahead with our presentation, and we can have a discussion as it evolves. And if you go to the PowerPoint that's up there, note that Crittenden Court has been operating a parking facility since the late 1980s. In 1995, the city of Cleveland enacted a parking tax and included an exemption from the parking tax for downtown residents. Actually, that parking tax exemption applies to anyone in the city of Cleveland, as I understand it, who pays for parking for their residents. So wherever you live, if you live in a mobile home in the city of Cleveland and you have to pay for parking, you get the right to file for an exemption for the parking tax. So it was revised in 2012. And over the past 27 years, the city has never indicated ever that Crittenden Court was improperly exempting certain patrons from the parking tax. Crittenden Court enters into a contract with each, we'll have it up on the screen, with each patron. And these are the contracts for nearly 3 decades. The city now is determined that there should be a third-party contract with the owner of the residential structure, AKA an apartment building, where the patron resides and the parking facility is required under 196.03 D1B in order to qualify for the resident parking tax exemption. We think the ordinance language, as interpreted using common English and it has been applied for over almost 3 decades, is pretty clear. At worst, the Division of Assessment and Licensing, in our view, has presented an ambiguous argument concerning its application, which is why I started out the way we did. We did have meetings with the Division of Assessment and Licenses, and I think that there's clearly confusion on their end about how this should be applied. Now,
Mr. Coyne, I just want to ask a question at this
yes.
point. You were here to see us, and how many meetings have you folks had since you were here?
I wasn't at the first meeting. We were retained subsequent, and there were discussions. What we then did have a formal meeting with the entire staff to try to work something out, and we weren't successful in that respect. We weren't successful in that respect.
Okay, sorry.
Okay.
Go ahead.
No, that's helpful. So going back on July 19th of 2022, the Division of Assessments and Licenses issued an audit report that concluded that the Crittenden Court Ventures LLC, I'll just call it the Crittenden Court Parking Garage, should be assessed an additional $87,192 in audit adjustments.
Can you repeat that number, please?
$87,192.02 in audit adjustments. I believe it was over a 3 or 4 year period. So that's why we're here, because we're appealing that, because they're basically saying that we should be responsible to collect that tax because it wasn't done properly.
All right, I'd really like to know the concrete dates of when that was, what that was assessed. Do you have it?
Yeah, it's,
So on
It's-
July 19th of 2022, the Division of Assessments issued the audit report to Crittenden Court assessing the additional $87,192.02 in audit adjustments.
and that's for a period from June of 2019 to May of 2022. That was the audited period, and you can see why we're concerned. We've been doing it this way for 27 years, okay, without issue. And I'll get into what the Cleveland Parking Association is concerned about too, but if I can then proceed. So we really have to go with the common reading of the definitional sections that define terms in the ordinance of the city of Cleveland. So under this exemption, which I'll get to in a moment, we need to look at the defined terms for those who are parties to the residential parking tax exemption application. So what are the defined terms? First of all, an operator means a person who conducts a parking service, whether in the capacity of an owner, principal, agent, lessee, mortgagee in possession license, or any other capacity. The parking garage or parking lot operator, okay, defined term. Second, patron. Patron means a person who pays a parking fee to an operator in exchange for parking occupancy by the person or another way, by way of validation or otherwise. So in other words, the patron doesn't send a separate check into the city of Cleveland for the parking tax. Just like a sales tax, the operator has to collect it and the operator would convey it, unless there's an exemption, okay? So that's how it's done. Now, transaction is also a defined term in the code. The transaction says and means the exchange of a parking fee for the privilege of parking occupancy between a patron and an operator. Patron and operator, those are the only two parties. No transaction shall be construed to include a parking fee where parking occupancy is not a material part of the transaction or where the parking space is provided to the patron as a complement from a merchant not regularly engaged in the business of conducting a parking service and who receives no consideration from any person in exchange for the occupancy of the parking space provided. In other words, if they don't charge for parking, they give you a parking space, there's no tax involved, okay? But the point is, the term transaction is a defined term. Within it, there are two parties to that transaction: the patron, the person parking their car, the operator, the person running the parking garage. Now, the exemption is found in section 196.03, D1B. The tax shall not apply to transactions with respect to which the patron is a resident of a single-family home, multiple-family dwelling unit, apartment, boarding house, condominium, or mobile home occupying parking space for the purpose of parking on site at that place of residence, or, and this is the important part of it, or at an off-site parking facility under contract to provide parking for residents at the place of residence.
Can you repeat that, please?
Or at an off-site parking facility under contract to provide parking for residents at the place of residence. So for off-site parking, so it's not where your actual residence is, it's off-site parking. Now, exemption under how the tax is imposed, it states that the exemption certificate shall be prescribed by the commissioner and include all information deemed necessary for the identification of the parties to the transaction, patron and operator, not apartment building owner, and include all information deemed necessary for the identification of the parties to the transaction and the authority from which an exemption is claimed, okay? So these are residential parkers who live somewhere in, probably more in the warehouse district, downtown, who park in the Crittenden Park garage, okay? That's who's affected. Those are the patrons that get the benefit of that exemption. Now, if we can go to the application, So this is what's been
To
provided.
what percentage of the parking facility are the parkers?
Residential parkers?
Right.
Audrey, can you answer that?
So it's about a 600 space garage. About 200, and I'm gonna round, about 200 are allocated to the Crittenden Court apartment building, which I'm gonna speak, there's no disagreement about them not paying a tax. And then we have another couple hundred, it varies between 150 and 180 off-site parking for like the surrounding buildings.
Various other residential buildings.
At one time I counted it as about 19 different buildings.
Is it open to to public parking as well, or?
It is open to public parking.
What is the occupancy rate for that?
We issue anywhere from 50 to 100 ticketed parkers per day. Transient parkers, not contract parkers, not monthly parkers.
Right.
And then we also have another couple hundred parkers that are businesses in the surrounding areas. Those are also, that we do tax all those.
And that's 200 approximately, you said?
Yeah, so you have approximately a third on-site parking, a third off-site parking, and a third businesses in round numbers.
Okay. Okay.
Okay, now.
Thank you.
Maurice, maybe if you could blow that up a little bit, that'd be appreciated. So then the application to get the exemption is provided by the City of Cleveland Division of Assessments and Licenses. So this is provided by the City of Cleveland. And this application specifically has been used since 2012 for 13 years. Prior application I can't speak to is, but it didn't have any requirement that you had to have an agreement with the owner of an apartment building to be eligible for the exemption. The application is very simple in some respects. You have the name of the parking lot or operator, Crittenden Court Garage. That's one part. The second is the name of the resident. And that, again, is the person who's getting the benefit of the exemption because they pay a monthly rate and they get the benefit of that exemption. They're the other party to this City of Cleveland residential parking tax exemption application. They have to identify their vehicle, license plate number, model and year, the lease term, and then they sign it. So it's the City of Cleveland's form that's been used for 27 years. Now, our position is that if the city wants to require the apartment owner to sign, they should issue a new application and they should amend the ordinances of the City of Cleveland to require that. When this first occurred, my clients, Ms. Mecklenburg could testify to it, said they would comply. If that's the case, if that's the rule going forward, we will comply with that. That's not happened. So this $87,000 is money not received by my client, nor paid by the applicants who were eligible as patrons under the codified ordinance of the City of Cleveland to be exempt from the tax. So that money has never been collected. So to come back now and say the Crittenden parking garage operator should, in fact, pay that when they've never collected it really operates as a penalty. And I think is patently unfair. And the interpretation is currently brought forth by the department is ambiguous and certainly arbitrary and capricious. Never done before. Now, there was a letter submitted, and I don't know if Liz referenced it, but this issue is a major concern in downtown in particular. A letter was submitted by Troy Mayer, the Cleveland Parking Association president, on May 31, 2023, supporting our position on this interpretation. We also understand that the Downtown Cleveland Alliance has concerns about this interpretation as well. The impact of this could be extraordinary to parking lot operators if it's applied throughout the city as well, because these are fees that were never collected, and they were under the City of Cleveland's exemption application. We've got thousands of these. I brought a box with me. Ms. Mecklenburg did. Hundreds, okay. We've got a whole box here. This is a whole application. This is mostly for 2022. So our position here is that we
So
believe,
these are residents
yes,
That have contracts.
Yes.
with
They have
the
contracts.
Yes.
Crittenden
right,
Court to
Yes.
park their cars.
on the City of Cleveland parking form. Which we were told to keep track of as a record that their residents eligible as patrons and residents of the City of Cleveland did not have to pay the parking tax.
Because they were under contract to park for the purpose of parking at their residence.
Right, exactly. So we have two positions. One, we think the ordinance, as I described it to you, is pretty clear. The procedure that's been provided by the Division of Assessments and Licenses has been consistent for a couple decades and did not require this fee to be collected in this way. In fact, it's because they're exempt under the ordinances of the City of Cleveland. That's number one. Number two, as best I can read in meeting with representatives of the department, and you'll hear from them, their interpretation is at best ambiguous and arbitrary. And I think that in either case scenario, this board, I think, is obliged to follow the ordinances of the City of Cleveland as you're required under our Constitution when you're sworn in, and determine whether this imposition of this tax is being lawfully requested. We believe it is not. And we're requesting this board to reverse the decision of the Division of Assessments and Licenses and not require this operator to pay the $87,000 assessment, which we believe operates really as a penalty more than anything else, because these fees were not collected from these individual patrons, residents of the City of Cleveland. That's our position.
And we'd also like to remind the board that Crittenden Court over the years has gone above and beyond in order to make sure that they're in compliance with what the City of Cleveland is requiring, and being in constant contact with the correct department in order and keeping track of all of the applications that they've been required. And over that time, they paid roughly about $1.4 million in parking taxes to the City of Cleveland.
In what time frame is that 1.4 mil?
Since the enactment of the parking tax.
Okay.
In what section, what section of the code did they pay under?
Oh, under chapter 196.
96. There's one other, we also, we'll submit, just for the record, the letter of support that we've received from the Cleveland Parking Association President Troy Mayer, which also points to concerns that have been raised by the Downtown Cleveland Alliance about this interpretation.
Liz, you have a copy of this?
Let me just.
I don't think that's.
And also, just for the record, in December 13, 2012, in a letter from the then auditor for Division of Assessments and Licenses, they submitted what's necessary to be eligible for the exemption. And this application form was provided to Audrey Mecklenburg. And there was no other information raised concerning we have to get an agreement with and evidence of an agreement with a apartment building owner and allow the eligibility to proceed. So I'd also submit
So
that.
this is from the
From the City of
director,
Cleveland, the auditor, I believe.
the auditor?
This, from that department.
I'll pass these down once.
Yeah.
And how was he supposed to?
Oh, right. Expand.
Okay.
So there's been no receipt of anything like this since 2012,
That's correct.
and it's 2023.
Right. Correct. 11 years. and you could page through these are, the city would have these are, and the city has these forms, but this is show you that we've always had them filled out when we take on a patron to rent space.
Those are from 2022?
They're
Just a
various.
sampling, yeah. Many of these are, there's another
We have
box. This is just as an
Okay.
example, that we've been doing that diligently, filling out that form, at no time requesting the apartment building owner to sign a separate form. There is no separate form to my knowledge, but to have them somehow authenticate that they're in fact a tenant of that particular building.
I just want to make sure I understand with the form
Sure,
and the tenant contracts.
right.
Do those contracts get submitted with the application to the city? Does that go with this form? Or no, you just name the resident or the
So,
patron? I should say.
right, correct. So that's how they keep track of who is eligible for it. If, like, my buildings, I'm in Lakeside.
Right,
I could not go in and fill this out because I would have to identify myself as a resident of 1100 Lakeside, which is an office building. So I think it's set up to have the patron, the resident, affirm that they're actually a resident in a building somewhere in Cleveland. And when I originally was retained, I thought this was sort of unique to downtown. Technically, as I understand it, and I'm sure the director could affirm it, it's throughout the city of Cleveland. So if you live in an apartment building at University Circle, and, given parking being now more precious, even though we're apparently giving variances away in busy neighborhoods occasionally, if you live in an apartment building, maybe your parking garage is full, you can, if you rent another space, you could get the exemption. And it's throughout the city of Cleveland. And I think it's really important because as the policy of city of Cleveland is, some of the apartment buildings are really designed to be underparked because we're advocating for alternative modes of transportation, RTA, scooters, bicycles, you name it, car share. You're going to see still probably during that period of time, people that don't get a parking space in their apartment building, but they're driving a nice car, are going to want it in a secure parking garage that has some security, has some cameras like they do. You're going to see that. So it's important that we look at this thing. And again, I come back to, if we're going to do this, do it the right way. The ordinance should be amended, make it clear, change the application that you've got to have the identification, some type of sign off from the apartment building owner, so that, I can't think of one, if the Hat Factory, is that an apartment building?
Yes.
Okay, if the Hat Factory has residents that want to park in this garage, they have to sign a separate agreement with the Crittenden Court parking garage.
It should be on the affidavit. I mean, basically what we got from the city of Cleveland is an affidavit, and then we have a contract with them too.
But that's not been done. Nor there's an application to do that, nor there's any reference in the codified ordinances of the city of Cleveland to do that.
And to clarify, this, the certificate is the residential exemption certificate that's called out in 196.03D2 that we put up on the screen, that evidences that, it calls for the certificate to show that it evidences the two parties to the transaction, which is what the certificate does.
Did we get any statement from the Downtown Cleveland Alliance?
Yes, it should already be in your packet. That letter from the Downtown Cleveland Alliance had been provided in the previous.
It's in the previous, I recall it. I can give it to you.
We didn't want to overwhelm you with more.
We received it.
That's okay, Liz.
And I guess lastly, I'd say too, the client, Audrey, talking to her and the team that owns the parking garage, they would welcome doing it that way if we got specific direction on an application that was in the codified ordinances. Nothing's been done to that to this date. I don't believe they can retroactively apply this given the history for 3 decades and the application that's provided to the parking garage operator who's been using it diligently for that period of time.
Any other questions, Ms. Rocca?
Not right now, but I'm sure I'll have more.
Ms. Holster, any other questions? Any questions from you at this point? Addressing this team?
Not at this point.
Okay, all right. We'll move on. Mr. Coyne, you're done?
Yes.
Okay.
Madam Chair,
Yes,
if I can make a copy of the,
I'll pass it
the
back.
exhibits, did the city give you something as well, or is that just a duplicate?
Oh, this is, yeah, that's what I got from the city.
This is the letter assessing the fees, I think. This is the audit report. I don't know if that was.
Okay,
I'll send it.
all right. Okay, gentlemen,
Great, thank you.
on
Madam
to you.
Chair. Thank you, Madam Chair and distinguished chairwoman and members of the board. Thank you for the opportunity to respond to the Owens complaint today. Now, the legal standard of review was cited, and appellant needed to demonstrate that the action of the city was illegal, arbitrary, capricious, or unreasonable. This is a heightened standard, Madam Chair and members of the board, and we will show that this standard has not been met. And so our ask for today is to affirm the decision of the commissioner on the basis that it is supported by a reasonable and correct interpretation of the applicable ordinance, that the city's ordinances attribute a differential standard to the commissioner's decisions, and that the division has actively worked in good faith to reach a settlement with the appellant out of deference to the suggestion of the board from the last hearing in the same matter, which was February 27, 2023. So I'll start with an overview of the legal issues in question and then hand it over to the commissioner and the chief auditor to provide testimony. I would also like to draw the board's attention to the evidentiary exhibits that were submitted to the board that directly dispute some of the allegations that were made by the appellant, especially during the first hearing and the request for rehearing documentation that was submitted to this board. This will enable the board to have a complete picture of the facts to arrive at a just decision at today's hearing. So we know that this board's authority is triggered under CCO, as the codified ordinances
I
section.
just want to, not to interrupt, I just want to object to that. We have not received a copy of this. This is the first.
Well, we did not receive a copy of the request for rehearing documentation either. It was submitted to the board.
We submitted it to the board.
Yeah, we submitted to the board too. We submitted that. I submitted it to Ms. Jones.
Okay, hold on.
I think Mary should weigh in on that. Mary, can you clarify with the appellant and the city submit documents to the board? Are they under the codified ordinances required to, or in any other way required to submit those documents to each other? I know how it works in litigation, and there are rules for that. And so I just wondered if those same rules apply here, or if there's any other rule that might apply. You're not sure?
I mean, ideally, whatever we, that our office should have been distributed them.
Okay, can we just wait? Madam Chair, can we wait till this is back to see?
Absolutely. Yep, that's just what I was gonna say.
Do you have a copy of this? This is the memo he's referring to.
I think this is the one that I gave to Liz.
And that was in the packet.
Sounds July 21st.
And a copy of one of the exhibits is an interview with an ex-employee who was mentioned by the appellant in the last hearing. A copy of that was shown to appellant during our meeting and was also submitted to Ms. Weber. She had asked for it. So one of those exhibits is a copy of the interview that was sent over to Ms. Weber, I believe about a month ago.
Yeah, we have that.
So the only thing, Mr. Coyne, that appellant did not receive is a copy of this memo?
Correct.
Okay.
And we've always, I've been here before, it's not my first rodeo. I've always presumed that when we file materials with the Board of Zoning Appeals, last I checked, the law department's 3 floors below, that they have an opportunity to
Right.
look at those filings, and I just assumed that.
We'll
It's a
wait for
public
Liz to
record, right?
come back in.
Right.
Okay. All right. Do you want to continue at this point, or you want to just pause until Liz returns?
We can continue, we can work around it. Again,
Okay.
the whole theme of this is our division has worked in good faith. When submitting it to Ms. Jones on Thursday, the email, our impression was it was distributed to the board members and to appellant, as was their request for rehearing documentation.
Okay.
That was submitted, but. we
When
can
was
work
it submitted?
around- Sorry?
When? Thursday?
On Thursday to Ms. Jones, Ms. Brittany Jones,
Okay.
by email, and she confirmed that it would be
Okay.
distributed.
All right.
But we're happy to work. Again, our intention is really good faith and just to paint a clear picture of what transpired and to show that appellant has not met the clear legal standard in play over. So if I may, Madam Chair, I can. with
Please
your
continue
permission.
that.
Thank you. So as we know, the board's authority is triggered under CCO section 196-17B as an avenue to appeal the commissioner's decision under the preceding subsection to protest the commissioner's determination at hearing. Now, the preceding subsection A2 and the codified ordinance 19608 also provide that any determination by the commissioner shall be prima facie correct and that the burden shall be on the petitioner to prove otherwise. The ordinances thus also provide that there's a deferential standard at play here due to the division's expertise in the matter of taxes, which comprises the expertise of certified auditors. The decision of the commissioner comes with a high standard to overturn. And as the ordinances speak to this directly, that such decision is prima facie or preliminarily correct. It should be noted that such language is not frequently seen in other ordinances. And since the determination that the board has to make today is whether the commissioner's decision was one that was arbitrary, capricious, or unreasonable or illegal, I will start with the definition of arbitrary as defined under case law in Ohio, and why the commission's decision is not such an arbitrary one. An arbitrary action, board members, under Ohio law is one that is fixed or done capriciously or at pleasure, without adequate determining principle, not founded in nature of things, non-rational, not done or acting according to reason or judgment, depending on the will alone, absolutely in power, capriciously tyrannical or despotic. And there's also a recent Supreme Court case that speaks about a heightened standard, often arbitrary and capricious standard of review, and that an agency is really allowed a broad zone of reasonableness to work with. So in this case, in this situation, you'll find that all the commissioner's decisions were supported by the law. Nothing was invented or arbitrary. The division assessed an excise tax on the privilege of parking occupancy under the authority of 19603C in the amount of 8% of parking fees, so that the total amount owed, as appellant confirmed, was $87,192.02. This was issued within 3 years from the later of the due date for the return, pursuant to 19618, our statute of limitations under the same section. And the amount owed reflected the lack of exemption because no contracts existed between appellant and certain places of residence. That's the language of the code. Under 19603B, now you've heard from appellant, the city's interpretation, the division's interpretation is that a contract is required between the places of residence and a non-parking facility under contract. The proposition qualifies the noun. Residents are being used in plural. It doesn't say each resident, it says residents in plural. So the interpretation is a reasonable one that is clearly stated in the ordinance that to qualify for an exemption, the off-site parking facilities, such as appellant in this case, needed to be under contract to provide parking for residents at that place of residence. Again, I just want to reiterate the language implies a contract between the place of residence for the collective of residents and the parking facility, since residence is used in plurality. And so the parties to the contract would thus be the parking facility and the place of residence. And this is a reasonable interpretation that the commissioner and his staff have held for many years. And in the first hearing, we were told that, and including the request for rehearing documentation, this was described as a seemingly new interpretation. one of the exhibits that is missing that you will have, which it's fine if it's not admitted. The commissioner under oath has spoken to his interpretation, and a former employee who apparently gave appellant some advice and guidance. And so
That was incorrect? Is that your testimony that a former employee gave the appellant incorrect advice?
I was not there. During the first hearing, appellant alleged that incorrect advice, misleading advice was given
Okay.
to them.
That's what the,
And identified a specific employee who did that. So,
A specific city employee
former
within the
city employee.
department
yes, with.
who is no longer with us.
Yes, who's no longer with us.
Madam Chair, can we see if we have that in here?
If not, I could just give you.
We were waiting for you to get back.
And that person was present in person when we heard this the first time.
No, they were not present in person. We heard about this person when appellant gave testimony during the first hearing,
Okay,
that they interacted with this specific employee who gave misleading advice, that
okay.
they were in compliance with this ordinance.
So I just, one thing on this note, I want to object to this as being hearsay on hearsay, even the memo, but we'll address it. But I just want to note that objection for the record, because this is a very serious appeal. And for the record, I'll say the department, Mr. Gangbani, have been very professional throughout this. We have a major disagreement on the interpretation of this. That's pretty much how it's been, to
Thank
be
you.
very
So
candid.
if I may continue.
Yes, please.
Madam Chair.
Madam
You
Chair,
good?
What, can I just ask these people for that
Yeah.
document? Did we receive, so the city is referencing a document from a former employee that states testimony about misleading comment. Was that in our packet?
This would be the packet that they submitted to us.
It would be exhibit B. It would be an interview.
Okay, it's in the back of the
It's in the
memo.
back. It's right
Okay,
down
I
the
got
back.
it. Thank
Got
you. Yeah, right here.
So, sorry, I'll wait for.
One sec. But this is the,
Yeah,
okay.
okay, here's 4 and 5.
Yeah.
Okay,
Okay, good, we got it.
thank you.
Okay, thank you
Thanks.
for
Go ahead.
confirming, if I may
Yeah.
continue.
Yes,
So,
please.
So, we've got that, and then also, so to sum it up in terms of the interpretation, the city believes, has always held for a long time, that this was your interpretation, was a reasonable interpretation of the ordinance. And to a certain extent, in the request for rehearing documentation that appellant submitted, they do say that it understands the city's position and interpretation of CCO 19603D1B. They also have agreed to comply with it going forward. Because really, this is a reasonable interpretation. If it was so arbitrary and capricious, one would not want to even follow through with it. But if I may continue. So in terms of what the commissioner did, he allowed for a protest to its determination of the $80-something thousand under the authority of 19617 to allow appellant their due process rights to challenge his determination. And in response to the protest, the commissioner abated $23,990.79.
Could you give me that figure again?
$23,990.79.
And I'm sorry, you said the city abated that.
Yes, this was when they appealed, the first appeal to the commissioner under 19617. So
Date of that, please?
Sorry?
Date of that, please?
Not that.
Is it in your
It
memo?
was undated.
No, I think it would be abated. No.
Yes,
No, I don't have it.
I do not.
We sent a letter to the amount, I can get that, but I'll have to tell.
We can get back to you.
Okay,
on
thank
that.
you.
And so the total amount.
Ballpark date?
Appellants received this
December.
in December of
December
2022, but it
22.
wasn't dated.
Okay,
But it should have been attached to the original application for appeal
okay,
as the
Confirmed.
actual
Great.
decision. of
Yeah.
state.
Yeah, she's
Okay.
right. It's the month of December. Thank you.
okay,
So the
thank you.
total amount owed was now $63,201.24. Now, this was what was further appealed to the board, and a hearing was held on February 27, 2023. So what I'm trying to map out here is, and forgive me for the repetition, is to map out that every decision was supported by a codified ordinance, by a law, and the heightened standard of this arbitrary, capricious, or unreasonable standard is not at play. And going back to that exhibit with the interview there, and this is an exhibit that was also submitted to appellant. A crucial matter in the first rehearing, if you remember, was that the appellant alleged it relied on guidance by the division staff to comply with regulations. Now, I was not there. The commissioner has been here for 22 years, and that document speaks to the testimony of the former employee. Now, I first want to look at what Ohio law says about relying on guidance from government staff. So under Ohio law, such alleged guidance cannot be enforced against a city because under Ohio law, estoppel does not apply against a state or its agencies in their exercise of governmental function. It's Chevalier v. Brown. Assessing and collecting taxes is a governmental function. To clarify, board members, estoppel is a legal doctrine that precludes a person from denying a fact that has become settled by a prior act of the person himself. In Kilco v. Cleveland, the city of Cleveland was not estopped from enforcing its zoning laws against an individual who for years had been wrongly issued licenses by the city to operate a restaurant on his premise in violation of the zoning code. Basically, the principle established under Ohio law is that a person who seeks advice from a government official assumes the risk that the information may be incorrect. Under this rule in Ohio, any alleged misleading advice provided by the division staff was to be taken by the appellant at its own peril. It would not create an estoppel against a public official. So this is a legality that has been set out in Ohio law. But now we also found that during the first hearing, and I was not there when appellant interacted with this member of staff. We found.
I'm sorry to interrupt, but you just said it's irrelevant, so I don't think we should even.
The conversation needs to go through the chair.
Right,
If I may continue, and you
Yes,
don't object.
sorry.
So we've.
If you have an objection,
Yeah, no,
hold,
sure.
yeah,
That
hold.
was an aberration.
Thank you, we appreciate that. Okay, so if I may, Madam Chair. Now, we've got Ohio common law, and then now we felt that the board had not received the full picture during the first rehearing, where allegedly guidance was provided to the appellant. Now, if you look at that exhibit, what the former employee revealed that at no time did the employee ever advise Crittenden or any taxpayer that they would qualify if the person lived within a certain distance from the city, and that her understanding of the residential parking exemption is that it applies to residents if there's a separate contract to park between the garage and building covering all residents. So this contradicts part of the information that appellant provided in the first hearing, excuse me. And then, again, just to go back in the request for rehearing documentation submitted by appellant, they call this interpretation a seemingly new interpretation. Again, as that exhibit shows, this employee had an understanding of the city's interpretation that a separate contract was required between the parking facility and the place of residence. And the commissioner who's been here for 22 years, who runs the division, had the same interpretation. And you've got that affidavit under oath notarized. And he's also under oath right now. So that's the only other exhibit. That in his affidavit, he acknowledges that he's always understood that the ordinance requires a separate contract between an off-site parking facility and the place of residence to qualify for exemption from parking tax, and that no member of staff was instructed to provide a contrary explanation of the aforementioned exemptions to parking facilities. So before I hand it over to the commissioner for testimony and the chief auditor for testimony, I would also like to emphasize the good faith efforts demonstrated by the division at each point of this case, from allowing appellant its due process right which they deserve at every point, to agreeing to meet appellant at the last hearing to work something out, in the words of the appellant. And I do want to also provide a synopsis of what happened during our meeting with the appellant, because the board did ask us to go back and work something out. So the city's understanding is we're going to go.
This is settlement discussion. I think it's inappropriate to bring that up to the board at this point. I really do.
Well, I feel the board has a right to know about
settlement.
What mean.
Mr. Coyne, we've heard you. We're gonna let the gentleman continue.
Note for the record.
Yep.
board, with your permission, if I may give a brief synopsis of what transpired. Our understanding going into the settlement negotiation was there would be some kind of, we'd all go in there with an understanding of working something out, in the words of the appellant, some kind of monetary settlement to work something out. When we got there, the appellants did, express their dissatisfaction, and we understand that they're dissatisfied. No one is happy with these decisions. And then we moved it on to the negotiation phase, which was really why we were there. The commissioner started the negotiation process, and no counteroffer was provided. So I'll leave it at that. No counter was provided, and our impression was we were there to work something out. So I will just leave it over there. And so again, the reason why I'm mentioning is the city went into this with good faith, and we came out with no settlement. And again, just to tie into the theme of good faith with the commissioner's division and his actions in general. Now, Madam Chair, the board's rules require a good cause standards to be met for a rehearing. Now, Commissioner, as counsel to the Commissioner and his division voluntarily and in good faith have decided not to raise objection to this rehearing, even though the city feels that the good cause standard may not have been met. This is what we have over here today. We ask you to find this arbitrary, capricious, or unreasonable or illegal standard. It's a high bar to meet. The commissioner and the division defers to this board. As per the last hearing, went out in good faith to try and work something out. They followed the law at each phase of the process, and they've always had this interpretation, which is a reasonable interpretation of the ordinance. Now, I'm going to pass it over to the chief auditor and then the commissioner. I also do want to state that this description of the division having an arbitrary or capricious demeanor, these are individuals who are professionals. The commissioner has been in his position for 22 years. It's not someone who just got on the job. Chief Auditor Butler has worked with the United Internal Revenue Service for over 32 years before working with the city, has dealt with convoluted audits, and this is really his area of expertise. So at every point, the intention of the city was to work with the appellant at every phase of this process. And really, the purpose of, as civil servants, we have taxes in place, not to penalize, but it's a civic duty of the commissioner to collect these taxes. And they all go into various, good causes. It's always a public interest element over here. The payment of costs go into permanent improvements in the city, elimination of deficits in city funds, etc. This is all in the ordinance. I do also want to mention that I know industry standards have been mentioned a few times with the parking associations. Those are not legal standards, just to clarify. Industry standards are voluntary standards agreed upon by members of the industry to have a functioning system. The legal standards are governed by our codified ordinance. So we do understand the frustration of the appellant. We've endeavored to work with them in good faith, and we defer to your judgment today, but the city strongly feels the high bar of the commissioner acting in an illegal, arbitrary, or capricious manner has just not been satisfied. And with that, I pass it over to the chief auditor, Madam Chair. Thank you for your time.
Thank you, Mr. Dempsey. Good morning.
Good morning.
It appears the focal point of this entire thing is basically on the interpretation of the ordinance. And you wouldn't mind what you find.
We need to send that down to Liz, please. Or are those copies for us?
Yes, they're for you.
All right.
There's like 4 copies.
Of the ordinance itself.
Okay.
I don't think Liz has to put that in the record.
No.
You want.
Okay.
So
Keep that with my stock. Okay.
Thank you.
Sir, go ahead.
So
I'm sorry, would you say your name again?
I'm sorry, Bernard Butler,
Bernard Butler.
I am the Chief Auditor for the Division of Assessments and Licenses.
Okay.
As Mr. Gangland has stated, I have a significant amount of experience, 33 years with Internal Revenue Service, 5 years, almost 5, September will be 5 years in the city of Cleveland. So it's approximately 38 years of conducting audits. I probably have conducted myself personally or overseeing hundreds, if not thousands, of audits and investigations. Okay, so the entire focal point here today really is on one thing. It really is the definition of the residential exemption. If we look at the actual ordinance and where we disagree at the ordinance. So the ordinance states the patron is a resident of a single family home, multiple family dwelling unit, apartment, boarding house, condominium, or mobile home occupying parking space for the purpose of parking on site at that place of residence. In other words, parking where they reside, where they live, or at an off-site parking facility. The parking facility is under contract to provide parking for residents. And where we disagree is it says residents at that place of residence. So our interpretation is that basically the only place that can enter into a contract with a parking facility for the residents, not a resident, but for the residents is the actual place of residence. That is that's our interpretation of this.
I'm sorry, can you slow down and repeat that, please?
Sorry. And
Just that one last part. So your interpretation
You're on a
of,
key point, so we
Yeah,
want
we
to make
wanna-
sure that you're clear.
I'll start over again, or not all the way.
your interpretation of
Our
residents,
interpretation is
plural,
that
with,
residence is plural. That is for residents at that place of residence. And the only party that can enter into a contract for the residents, plural, would be the place of residence. So basically, if I'm the owner of ABC parking lot or ABC apartment building, I can enter into a contract with Brittenton. Brittenton, I need you to provide parking for my tenants at ABC apartment building, ABC apartment building. I own ABC apartment building and I want to have a contract. I don't have parking, or I don't have enough parking for all of my tenants. So I find a parking facility. I enter into a contract with the parking facility to provide parking for my residents. That is our interpretation that says residents. That there has to be, we believe there is some kind of parameters in place. And just looking at someone, and I know this is only about the city of Cleveland, but when you go and you do research, various cities have things. In some cities, residential parking is identified by, it's part of the lease. You have to have it in your lease. One city has it where it has to be within a city block. Other cities have certain things. So the parameter, we believe that the most reasonable interpretation is that it is the place of residence. When we're looking at the plaintiffs, it would be basically individuals having contract. Nowhere in here does it say, as long as you just have the patron has a contract with an off-site parking facility. If that would be the case, they could take out parking for residents at that place of residence. There would be no need for that verbiage. It would just be you park where you live, or you can park off-site at a place that you have a contract with. But the city council went through the problem of putting all of this verbiage in here, parking for residents at that place of residence. So that is what our basis for our decision, basis for what our position is. It's based on that particular statement. On that, there's basically whatever these 14, I think I counted 14 or 15 words. That is our basis for our decision that we made. It's based on that it has to be, because it can't be whether it's, if you look at the plaintiff's position, you could have a contract with any off-site parking facility. Would it be 5 miles away, 4 miles away? Would it be, can you live somewhere on East 55th and then have a contract for a parking place that's downtown? That would, in our opinion, would be arbitrary. What makes it not arbitrary is that you're parking where you live, or you're parking at a parking facility that's been provided by the place where you live at. That is how we interpret it. So that would be my first point. The second point is about the 3 years and going back. So in the 38 years I've done this, there's always been a statute of limitation. There's always been a amount of time that you could go back. Audits by their nature are going backwards. They're basically, you can't audit somebody for the future because you have no idea what the future holds. So whether it's the Internal Revenue Service, whether it's the state of Ohio, all municipalities, this 3-year statute of limitations is common. It's been since 1985 when I began my career in tax administration. It has always been available to go back 3 years. That is the normal, that is the standard. For like I said, federal, that is the standard for the state, that is also the standard for the city. For municipalities, I think it's section 711A of the Ohio Revised Code that talks about municipalities having for income tax, the ability to go back 3 years.
lastly, I want to talk about, and it has been brought today, about a new interpretation. It is our position, the Division of Assessments and License, that there is no new interpretation. It has always been this interpretation. As I had mentioned in a previous one, we recently conducted, or maybe in 2022, 2021, began the process of conducting audits. And by doing this process of conducting audits, all of our taxpayers are new. They're new to being audited. So every issue we find is going to be a new issue. It's going to be something that's transpired because they've never been audited before. This is just a product of us now having a compliance arm and going out and conducting audits. The purpose of an audit is to verify the accuracy of the tax returns. And so that's what we have. We go back to the ordinance itself. The 3 years are in the city's ordinance, Ordinance 196, that covers parking. It has a statute of limitations that indicates that we have 3 years. So that is part of our ordinance. We have parking taxes, we have emissions taxes, we have hotel taxes. They all have a statute of limitations. This is common practice. And I would also, one last point, and thinking about, and this is not a best analogy or a perfect analogy, but the mere fact that people have filed returns for years and years and years doesn't mean that this was accepted by the city or for that, I'll use the Internal Revenue Service. Only 2 or 3% of the people ever get audited. But that doesn't mean because you were never audited that your return is correct. If you have something on your return, you're claiming your cat or your dog as a dependent and you filed it for 27 years and the IRS never caught it, doesn't mean it's correct. What makes it correct is what is the law? What does the law state? And in our opinion, the ordinance clearly states that for parking for residents at that place of residence. So that is, and even I'll use another example analogy, even driving to work today. The speed limit is 60. I may have been going slightly a little bit more than 60. But if you travel on the road and you constantly go past the speed limit, and one day the police pull you over, you can't say, you know something, I've been on this street for 30 years, driving on the freeway for 30 years, I've never been pulled over before. You can't give me a ticket. Well, I'm not sure that would work. But basically the speed limit is the speed limit. And it's the same here. The law, the ordinance is the ordinance. And what it clearly states in our opinion, our interpretation is parking for residents at that place of residence, and the plural residents. That being said, I will now turn it over to Commissioner Stevens.
Thank you. Madam Chair, members of the board.
Are you comfortable in that position, sir? Do you want to move over a little?
Yes, it's a little bit better.
Okay.
Okay. Madam Chair, members of the board, it's been stated that this is a new interpretation, and it is not a new interpretation. The interpretation has been the same. The issue has been that no one has went out and enforced it. The city invested in auditors in order to go out and verify the accuracy of returns, and that's why we hired, Mr. Butler with his extensive background in order to head up the division. And we have CPAs working for us who go out and do these type of audits. And so when Crean says that they've done it the same for 27 years, I have no doubt that, they're correct, that they've done it the same for 27 years. However, where we differ is, was it legal when it was done? The city holds that, our interpretation is extremely reasonable and has been the interpretation for, at a minimum, the last 22 years. During the last hearing, it was mentioned that, Julie Weaver gave pretty much instructed them what to do. And Julie Weaver, all throughout my term, has sat right next to me for 4 years. She sat 4 seats away from me, and we regularly talk about the interpretation of the ordinance. And I do not recall ever written court or residential parking ever coming up in conversations. The interpretation of, off-site parking facility under contract to provide parking for residents, plural, at the place of residence, we believe is extremely reasonable, and the way that City Council pretty much meant for it to be. that had to be with the place of residence. As far as, the letters from, DCA and the parking association, we, of course, care about, everyone in the city and trying to make sure everyone has an understanding of the law. However, their letters are rooted in opinion, it is not rooted in law. And the law has been stated as witnessed from our attorney, as well as our, chief auditor. And so I would like to pretty much close with our interpretation has been the same from the very beginning. It has not changed, nor was guidance given to Julie Weaver to say that it was between the patron and the off-site parking facility. That conversation never happened. And with that, I will close. Thank you.
Yes, sir.
Yes.
Yes, you may.
Just one final notes that technically by the ordinance, we were allowed to go back 6 years. When there's a 25% understatement, the city chose not to do that, not to implement that, only to use 3 years.
Thank you. 1 second. Ms. Holzer, Ms. Roca, do you have any questions to the gentleman that just spoke at this point?
Not right now, I'm still formulating my thoughts.
Okay, Ms. Holzer?
Just
Okay.
following
Yes, sir.
along. Thank you.
Okay.
Yeah,
Yes, sir.
through the chair, and based on the board's guidance, we did meet, and attempted to settle. We offered a settlement, without a counter being made. And so we as a city attempted to follow the board's, guidance in order to resolve the issue to the best of our abilities.
I have a question because we had a number of appeals or cases with appellants coming before us that had been assessed for different things. It was like a flurry of them, a cluster at that particular point. And I know one has ended up in common pleas, and we had hoped that there would have been some meeting of the minds in this case, which is why I think it was postponed and sent back, hoping that there would be some resolution without having to come back to us or take further action. So, did assessments start recently? I mean, I'm just curious as to why we had a number of cases all clustered together.
Through the chair, I'm not, I don't remember which ones that you're referencing. There's quite a few of them.
Right.
We're a part of, but for the last, I would say 3 years, we've been out doing hotel tax, admissions tax, and parking tax. And then this is our first parking tax.
Okay.
For where this issue has arose. And so it's probably due to the amount of audits that we're actually performing now. Whereas before we did investigations, and our main concern was finding those who clearly were not complying with the law and bring them into compliance with the law. Now we're going out and looking at folks who have complied with the law, make sure that they are interpreting and applying the law correctly.
So there has been a change from investigations to doing the current assessments.
Audits.
Through the
And-
chair, yes.
Okay. All right.
And Madam Chair, I don't want
Yes.
to interrupt you, I just wanted to make sure, did I hear correctly that the audits started in 2021?
Through the chair, we've started slowly and have begun to wrap up, and I would defer to our chief auditor for the very specifics.
Yes, I was gonna just respond, first if I could to the Commissioner Megan. So whatever has been involved, I think there's only been one tax case. I oversee tax administration, so we're probably doing, other parts of assessments and licenses that, the cases that,
Yeah.
they're saying, but it wouldn't be, tax administration. There's only been this case and there was one other case, it was almost 2 years ago. I think we resolved outside of the issue of, parking the criminal case, criminal, so.
And to Ms. Roca's question,
You started the auditing and enforcement in 2021?
I believe it was in 2020, or, yeah, about 2020. Because 2020 was the pandemic and we started, I think Mr. Cooper, one of our auditors, has been here for 3 years now. So it would have been started in 2020. So 2021 was when we started really going out. We were able to go out to the field whenever COVID has subsided a little bit.
I just want to clarify, sorry, to belabor this point, but I want to make sure I understand in my mind. So prior to COVID, were audits being done or audits, you did not have auditors?
We didn't have auditors. We started off, I started October of 2018. I hired a couple of auditors. It didn't work out. Then we went through the process. Mr. Cooper, who's with us now, is started in 2020. So that's really 2021.
Okay,
really,
thank you.
Really actually started going out and doing audits.
Thank you.
all right, so that to some extent explains the timetable of
Yes, it does explain the timetable.
Yes, okay,
Madam Chair, I do have a question.
yes.
Mr. Butler mentioned something about an enforcement arm. Do we have a date on that, or is this the same as just acquiring those auditors?
Yeah, acquiring an audit. I said enforcement on compliance, basically. So prior to this, because there was only, prior to my arrival, there was just one employee in tax administration. That person, Julia Weaver, really was responsible just taking in the returns, filing the returns, taking the payments, putting them in the system, taking them over to Treasury. So there really was, whatever you filed on your return, what you filed on your return, there was no type of compliance. We never verified what was on the returns.
Does that answer your question, Liz?
Yes.
Okay. Anything else?
No, I'm sure that the appellant has rebuttal.
Yeah, we'd like to.
Yeah, that's where we're gonna go next. That's where we're gonna go next.
I'd like to present a rebuttal. And first, I'd like Ms. Mecklenburg to address some questions she's had about what's been stated thus far.
Yeah.
Audrey?
And I'm gonna say at this point, if we can try and keep everything succinct,
Yep.
focused, and as brief as possible, please.
Okay. In the ordinance, they're reading it as a contract, a third-party contract. In the last 30 years or whatever, never has any third-party contract been mentioned. So under contract, in a parking occupancy tax thing would normally mean a parking contract, right? Parking contract. And I have to address at that place of residence, they're construing that as a third-party contract with that place of residence. I know it's a small word, at or with, but never in the ordinances say with that place of residence. So even Mr. Butler just mentioned, they're construing it to mean a contract with that place of residence. I know it's a small word, with or at, but it does make a difference if they're using the language in the ordinance to be their thing. Okay, so we said the letter in 2012 does not mention a third-party contract to be in compliance. In the resolution that Mr. Butler talked about, they mentioned what we were hoping is that we would rewrite the ordinance, or they agreed that the ordinance is confusing, and they are already in process of rewriting the ordinance so that it's less confusing. So they agree that it is confusing.
It's great. If I may.
No, I think she could finish.
Are you objecting?
Oh, it's a she, yes, because she pointed towards me, but with your permission.
No, with Mr. It was mentioned in the meeting that we had in April.
Right.
That they were already in works of rewriting the ordinance because there was confusion. They thought it could be rewritten.
So if I may, but I can wait.
Hold, please.
Okay.
Unless he's objecting, is he objecting?
I am objecting to the use of the word confusing. If I may speak to that, we clarified that our stance is the interpretation of the ordinance is not ambiguous. We did say that, we did not say it's confusing, and I believe I said that clearly in the meeting, that we maintain our stance that it's not an ambiguous interpretation.
And I would like to address what Mr. Gagliani said about at that place of residence, because it is used to determine where they park for their place of residence or at that place of residence versus at their place of business. So say, for instance, two places that charge parking tax I'm gonna use. University Circle and downtown Cleveland. So one person works and lives in the other. They would only be exempt from the parking tax in one at their place of residence, not at their place of business. It doesn't matter which way they go, they're gonna pay tax at one of their locations. So that's why it was in there. I mean, I was around when this ordinance was written, and that's what it was explained to me at the time. And that's the way we've always interpreted it, and that's the way the parking world interprets it.
And if I may join at this time, their explanation, interpretation is what's confusing. That's what's confusing. I'm going to go to Merriam's dictionary first. If we can accept that as a reasonable interpretation of the English language, because it's not residence, ENCE, that's in the code or the application, it's residence. And I'll get to Ms. Weaver's comments. Residence, RESIDENTS. The noun residence, not residence, a residence, ENCE, which might be a physical structure. It's residence. What's a residence? One who resides in a place. Synonyms, nouns, a dweller, an inhabitant, an occupant, a tenant. Not the landlord, not the building owner. There's nothing in the code that provides that, which is why they're going to probably redraft this code sooner, I hope, than later. And we didn't not counter. We said we're not going to pay a penalty on taxes or assessments not collected. It's a penalty. They haven't collected this money from residents of the city of Cleveland. Under this interpretation, one can conclude they can go back and say, you know what? We've got to charge you this because it's a tax. That's unfair, and it's arbitrary in how they're going about it. Ms. Weaver, based on Ms. Mecklenburg's recollection, explained that it was the residents who were in the agreement, not the owner of the apartment building. And even in the memo, which I object to being used because it's an out-of-hearing statement, offered to prove the truth of the matter asserted. It's improper, it's not sworn, but she does say it's her understanding, not this is the way it is. It's her understanding of the residential parking exemption is that it applies to residents, ENTS. And then she gets into of the apartment buildings, which have a lease. And then she goes on to talk about, or their separate contract between the garage and building, which again is her understanding. Never has it been done, ever. So that we're supposed to accept that. Now, I also go back to if residents, which they think is an important term to prove their position, why is it not an operative definition under section 196.02 entitled definitions in the parking occupancy tax? It's not. What is in there, however, is the term operator and the term patron and the term transaction. It is an interpretation that is very confusing from what they presented. And I don't see how anyone could disagree with that. In addition, as it relates to the standard, the ordinances of the city of Cleveland on these kinds of matters, the appeal process, this board shall have authority to amend, vacate, or affirm any such decision appealed from in conformity with the intent and purpose of this chapter. So you have the authority to vacate it, and that's what we're asking you to do. And I think it's important that you look at the law. Now, we didn't see their brief, but the standard under that section, you have authority to vacate this. And this is a case law, Smack and Snack, Inc. versus Mayfield Heights, and it's from the 8th District Court of Appeals. And I would direct you to page 5 of that.
Tony, we can't reach that. I got it.
I'm sorry. I'm sorry. And counsel as well. If you go to page 5, I think it's highlighted, so it's not. Under paragraph 10, it states at the outset, It must be observed that we are here dealing with tax law, and as such, it must be strictly construed. If there is any doubt as to whether a particular ordinance levies a tax, the doubt must be resolved in favor of the taxpayer, must be resolved in favor of the taxpayer. And then in the next paragraph, and that's a Supreme Court decision, it states that in approaching the interpretation of statutes imposing taxes, it should be recognized at the outset that the rule of strict construction should be followed, and that where there is ambiguity or doubt as to the legislative intent, the doubt should be resolved in favor of the person upon whom the burden of taxation is sought to be imposed. It's clear law. They want to get into the definition of residence, not in the code of the city of Cleveland's parking tax regulation. They've never enforced it over, to our knowledge, anyone in the city. And this is a real concern because the precedent here is substantial. And I think it's ambiguous. Even Ms. Weaver's comments are about it applies to residents of apartment buildings. And just the plain reading of the city's application doesn't reference the owner of the apartment building. It doesn't. So how do we get into residence? Their definition is residence means the apartment building owner. It's not in the code. It's not in Webster's. So we really believe this is a huge disagreement. And we think that fundamentally, the way they're interpreting it is ambiguous. The plain reading of the ordinance states that the agreement is between the patron, the resident of the city of Cleveland, the taxpayer, and the parking lot operator. No third party agreement is referenced. If they want to do that, we're more than willing to start doing that. We believe that it should be codified. We believe that this application should be revised. It hasn't been done. And I say, shame on the city of Cleveland. If that's the way this is going on, shame on the city of Cleveland. I'm a resident of the city of Cleveland. And this has gone on that long. And now all of a sudden, lo and behold, we're going to do it a new way without changing the code, without changing the application. I think it's fundamentally unfair. And we believe their interpretation is completely ambiguous, and the ordinance itself speaks for itself. We ask you to vacate the decision of the director.
One last thing, just referencing him, the commissioner himself in his letter in December, his opinion in December said Crittenden operated in good faith and attempted to abide by the ordinance. Not like we were doing it capriciously, we were attempting to abide.
It's the city's current interpretation that is arbitrary and capricious. We'd ask this board to vacate the decision of the Division of Assessments and Licenses. And respectfully, I think that's the right thing to do.
That concludes your rebuttal,
Yes.
gentlemen?
Just like to,
Well, I don't think they get served rebuttal. I object to them getting rebuttal. The appellant goes first. And I know, Madam Chairman, and I'm trying to shorten the meeting for you.
Just want to know if there's any final comments.
just like to thank you, Madam Chair, and refer to the board. We'd like to reiterate that the standard is a high standard that has not been met. We've supported the commissioner's actions with the applicable codified ordinances. And we've got professional experienced staff within the division. A lot of deliberation was put into the matter, including the board's advice at the first hearing. So we would urge you to consider everything in totality, especially the legal standard of review in affirming the decisions of the commissioner.
Great, thank you.
Well, and I'll just say in response to that, since I've been doing interpretation of the city codified ordinances for 35 years in other cities, and I have not seen an interpretation this outlandish. The term residence is the term they're really holding their hat on. It's not even in there. It's not even in the code. It's not right. It should be amended, and the application should be amended. And that's our position. We ask you to vacate the decision.
Thank you.
That's council. We believe our interpretation is the most reasonable interpretation.
I want to go back and forth. I think it's unfair. I really do.
Okay.
I think it's unfair.
We should be able to respond to this.
I have a question, gentlemen. When you moved from doing when you started before you moved from doing assessments from the investigations, was there any kind of outreach, or did you forewarn the people? Did you say this, did you update? Did you say we're going from investigations to assessments? This is how we're going to be approaching it. This is our expectations at this point. Did you do any kind of education, outreach, before you switched to doing the assessments? Since there was a fairly recent change starting in 2021, in terms of making that sort of change in how you are handling things.
Through the chair, it's the presumption when someone files a tax return that the tax return is correct. Did we reach out and say, as of this date, it is our expectation that since we're going to be looking at your tax return, that the tax return is correct beginning on such and such date? No, we did not. The ordinance clearly states that the city has the right to audit and go back and do these things. But we did not do any type of public outreach to say, as of this date, you're subject to audit.
Okay. No, go ahead. I think they want to speak to that as well. I have a totally different question,
Just
so.
want to say, we do send out an audit letter. We don't just show up. We send out an audit letter sometimes like 2 months in advance. The city of Cleveland started initiating audits. We're conducting an audit review. The purpose of the audit is to confirm the accuracy of the tax return we filed. If you have any questions, give us a call. So they receive a notification of audit letter. The various tax bills. As long as, as I said before I was interrupted, basically, we believe our interpretation is reasonable interpretation. The fact that at the end of the day, we believe that basically the ordinance was written to allow residential parking where you live, or parking at an off-site facility provided by the place that you live in.
So, Madam Chair, may I ask a question? And this
Yes.
is going to take us down the path of just the strict language of the statute, of the ordinance. It looks like this ordinance was passed in 2010, and I think, at least for the commissioner, you were here during that time. Do you recall why residence was not a defined term?
Through the chair, if memory serves me correct, I went and did research, and this section of the ordinance was not amended that talks about the residential parking exemptions. That was not what council looked at when it was amended in 2010.
Oh, I see. Okay, so so this language that we're talking about today was from prior to 2010,
So the original.
in the 1985 language. 1995. So it has not been, residence has not been a defined term since the 90s. Okay. That answers my question on that point.
Brother, the actual same language is in the ordinance for Cincinnati and Sandusky, not brother, but the same language is used in other cities.
It actually is relevant because the way these codes are often drafted, they go to model codes, they go to other cities, and you know what? One of my colleagues, one of my lawyers misses it, and they miss something, and they don't do it properly. It happens periodically with ordinances that are drafted using other cities. And in this case, that's exactly probably what happened. So it's been followed in a way that's reasonable based on strict interpretation of the code, but now all of a sudden, there's a different opinion, and we think it's arbitrary and ambiguous.
Is it correct that this is being redrafted at this point?
Well, Madam Chair, any redrafting in legislation is within the jurisdiction of council.
Right.
The commissioner intends to proactively take any commentary to suggest a redrafting, but that is really on council. It will need to go through.
Right, I'm just
any
curious because this board has a large number of cases with regard to parking. And very often variances are granted because property owners make arrangements for off-site parking. So we're giving this time and a lot of discussion because this could very well have an impact on what we do with other cases.
A very large impact.
A very large impact. We have cases where we make homeowners park off street because they can't get a driveway in. We have apartment buildings that have no parking that seek variances. And if they make arrangements for off-site parking with a third party, they are often granted variances for parking less than what is required. So this has a huge impact on us. And I'm taking this very seriously because this is an opportunity for change. When these cases come before us, they very often are an impetus to make improvements and changes for the city and for how the city handles things for the residents of the city. So that's why I asked if there was any outreach before things were changed. We are public servants. We are here to serve our community. And so we need to make sure that we're doing our job to the best of our capabilities. And it is for us as experts to foresee what needs to be changed and what has to be clarified. So that's why we're giving this the due diligence that we're giving.
Appreciate that, Madam
All right.
Chair. And so the commissioner is trying its best to incorporate.
Right.
any-
I understand that.
As it was even with the first hearing, and we give great deference to the board as always. And also just to clarify with, we do have a statute of limitations within the ordinance, which sets it at 3 years. So that is a check in place within the legislation itself, because council probably foresaw that this could have gone back, I don't know, 20-something years. That there's a check in place. And again, we defer to the board, we defer to council. Commissioner is proactive and taking an insight. Really, the crux of the matter over here, and we do understand the frustration of calling to the standard at stake over here is a very high standard.
It is.
And so, which is the basis of our risk request, in addition to all the other good faith endeavors that the division has.
I think this could set a precedent. And again, it very often is an impetus for change. So, yes.
And through the chair, there has been discussions within the administration on looking at this in more detail, given all the factors that you had mentioned, such as, apartment buildings, not having enough on-site parking. Administration is aware of the issue and is actively looking to see what can be done to address that issue. Just wanted to let you know that.
We're at a turning point, and I think we need to, definitely, thank you.
Madam Chair, I'm not sure if you
Yes.
saw our
Yes, I did.
attorney's hand.
Yes.
Given the seriousness of this whole thing and the implication for consistency, it might be important for you to know what, when you began audits, what were they finding with everybody else? And was everybody else going to find and paying fine? Are they the only ones that are healed?
That's excellent. Thank you. Can you, gentlemen, can you address that, please?
Yes, so as I indicated earlier, we have a variety, well, I shouldn't say variety, but we have emissions tax, we have parking tax, we have hotel tax, we have motor vehicle leasing tax. But those are the 4 taxes that we already see. So for hotels, one of the issues that's come up is that in our ordinance, pet fees and smoking fees are taxed. Some of the hotels were not reporting the smoking fees and pet fees. In other words, when you go to a hotel, well, most of them you're not supposed to smoke. If you smoke, they charge you whatever the smoking fee is, but the hotels won't report that. That is also part of the lodge. So those were some issues with parking. This was the first parking facility that we come across with the residential. There's approximately over 100 parking facilities throughout, even actually more than that. So we've looked at, for emissions tax, there's been some issues with people not reporting all of the emissions. There's been issues with people not reporting the tax correctly in both areas. The tax, the way it's implied in most of our taxes, that is included in the price. So some of our taxpayers, where they take the gross multiplied by 8%, but you're supposed to take the gross divided by 1.08, and then you multiply that what's left by 8%. So there's been instances where people have filed their returns for the wrong way for years and years, who have gone pay more than they're supposed to pay. In those cases, we ended up issuing a check or giving them a credit. So smoking fees, pet fees, one of the things that's come up recently with parking is not reporting lost tickets, where individuals, they're charging the customers, and the customer says, I lost my ticket, but they're charging the customer, they forgot to put it on their tax return. So those are some of the issues. There was a couple of emissions taxes where they didn't, there were suggested journal entries that didn't make their way to the general ledger, to the tax returns, that they weren't, so they had to pay the tax. Most of our taxpayers have paid, when there was an assessment of deficiency, I should say, there's interest and penalty, they pay their interest and penalty, and that's pretty much how it's gone for the most part. I think of appeals, this is the only one as far as from audits. There's other
So
things.
with regard to parking, is this the only one that has been audited and reached this? Or have other people paid?
They
As was the question.
They paid, I'm sorry, yeah, they paid, basically, sorry.
So this is,
But they didn't have residential.
Yeah, this was the first residential.
so this is the first,
residential.
Yeah,
so this is
Okay.
the, I just want to, I'm sorry, Madam Chair,
No, no.
clarify too.
No,
So, as of the new audits that started occurring in 2021, this is the first challenge to the parking exemption ordinance that you have,
The residential exemption, yes,
residential exemption, okay. So presumably, there might be more.
yes.
Okay, as you audit, it is foreseeable that there could be additional challenges, additional parking facility owners who believe that the ordinance is interpreted differently.
Yes, and I took a look, I went back and looked at all the individual tax returns to see how many of them actually had a residential exemption on.
How many
It's
is it?
a relatively small amount. It's less than, I would say less than 10% of all the returns. So there's, some of our taxpayers, they may operate 50 or 60 parking facilities, but going back and looking at each return individually, I believe the actual count was small. It was
so 10% of what amount?
sorry.
Total.
The total returns, if there was
Right.
like 120 returns, maybe 10 of them had.
So is that the number, 120 of parking returns?
I don't remember the exact number.
Just trying to get a scope.
Yeah, I mean, it's probably somewhere along that line.
Okay,
Okay,
all right.
all right.
Does that give a better?
Yeah, no, I think I have all the information that I need,
Can I
Okay.
just
unless
clarify one
Ms.
thing?
Holzer has
So
additional
those
questions.
120 returns, some of the returns might have multiple parking facilities, if that makes sense.
Yeah, that does make sense. They can
Yeah,
list
so-
all their parking facilities on one return.
Right, yes.
Yeah.
So the total facilities is somewhere over like 240, 250, something like that. Total parking facilities, but some, they're grouped together, I mean, but that returns could be filed. for
Okay.
15.
All right.
So I just wanted to.
No,
Thank you. I appreciate that.
we
Those
are,
facts.
we are going after
Minute details.
minute details because this is so important. Okay,
And I can get you the actual figures if you need it.
I think what you've testified to today is sufficient for this purpose.
okay.
I do want to, last comments real quick. I don't think there's any dispute between the city and the appellant that these are actually residents that would normally qualify for an exemption. if there was no dispute on the ordinance. We kind of feel it's more of a paperwork issue than a money issue, and that's where we kind of disagreed with the settlement. When we were having the audit with Mr. Krupa, he said that maybe we should have something in writing with our adjacent apartment buildings. And in the first packet, I submitted some of those letters that came from the adjacent property owners. And in January, I wrote to Mr. Butler asking what would a contract say with a third party, because it's not mentioned in the ordinance, and what other things that we have to do to comply, and none of that's been addressed either since. So I just wanted to say that we really are trying to comply. It's very confusing, and I have reached out over the years and done the best I can to comply. Did not collect the tax, and the whole amount is a penalty to us.
Yes, sir.
Through the chair, when you was going on talking about the scope and why this is important, you had made a statement that this board makes the property owners make arrangements for off-site parking, which is what we are interpreting the ordinance to say. Just wanted to bring that to the forefront.
But in fairness, the arrangement is, I need a place to park, and you're in the hat factory, Crittenden Court parking garage, she has spaces. She has informal agreements with folks to call. I mean, that is how it sometimes happens.
Right.
But you gotta look at the ordinance and the language. It should be changed. In fairness, and I might add, about the parking facilities, they provide security, they have cameras, because it's residential. It's incredible to me. And I think we have a right to go to these folks to collect the tax then. That's what they want to do, to tick off all of these residents, current and former, of the city of Cleveland, because the tax wasn't administered properly. Really?
Okay, that sums everything up.
Ms. Holzer has anything?
Ms. Holzer?
No, thank you.
All right. Ms. Roca?
Sure. Hearing the extensive testimony that we've heard today from both the appellant and the city, bearing in mind the very high standard the appellant has to meet to reverse an administrative decision of this nature, and also bearing in mind the deference that the city has and enjoys under the law as well. I think it's important that we note tax ordinances should be clear, and taxpayers should know what they're supposed to pay. And with that said, I move to vacate and reverse the administrative decision of the city, and I will entertain a motion.
That was you making the motion.
Me making the motion, I'm sorry.
You made
A
the
second.
motion.
A second.
Ms. Holzer, it's to you for the second.
I second.
Thank you. When you're ready, Ms. Kukla?
Call the roll. Ms. Holzer?
Yes.
Ms. Roca?
Yes.
Ms. Faith?
Yes.
Calendar number 23-011 is granted. Will be ratified next week, and we will send the appellants a letter.
Thank you, members of the board.
Still have a lot of agenda to go.
Sorry about that.
It's all right.
Yeah.
So, Madam Chair, the appellant in Mr. Dial, he did contact our office, or Brittany contacted him, and he is withdrawing his appeal. So calendar number 23-056 is withdrawn.
Hang on.
We have to get ourselves together here.
Yeah. Okay, 23, Ms. Holzer, are you with us? 23-056 is withdrawn.
Yep. Mm-hmm.
Got it.
Then we'll need to dismiss 23-069. The appellant, we were not able to contact him, and he did not contact our office about his absence.
Okay. Without objection,
Without objection.
Without objection.
calendar number 23-069 is dismissed.
I believe that's the end of our regular business.
Um,
We have old business.
West 128,
That that has
we
been.
rescheduled,
we
sorry.
rescheduled that.
Oh, they're rescheduled. Okay.
I feel like that was 4 days ago.
Yeah. And then,
So,
We have old business still, Maurice.
Oh, you didn't do it?
No, we haven't done our old.
not yet.
Look at me, someone's a star.
I closed it, hold on a second.
can't believe I have to work after this.
Okay. So I have mine, it's in grayscale, so I need old business in
Color.
There you go.
All right. So the second one and it's in blue, what's the significance of that?
So this is regarding West 136th Street, 3763. The appellant was granted variances to establish use as an in-home salon business.
Yes.
At the end.
Yes.
She stated, and this was after the motion, after everything
Right.
was done. She stated that the hours of operation were not correct. So we need to bring her back and have all that
Yes.
stated, for the
So,
public record.
and this brings up a point because, in my notes, I had Monday through Friday. We repeat, there's a reason why we repeat hours of operation and things to make sure that you get it, make sure it's heard. And so now she's saying that she wants 7 days a week rather than Monday through Friday.
That's right.
So she.
So she needs to come back.
Mhm.
So, let's just handle that. So without objection.
Without objection.
Without objection.
Okay, so she can come back for that.
So we can put it on July 17th. That's our.
Yeah, that's fine. Councilman Casey was present for that and his approval was based on having conditions, so. And so we have calendar number 1 and then 5 through 10 without objection.
Without objection.
Without objection.
Okay.
And then, calendar number 22-182 on Auburn Avenue. We did receive comments from the Development Corporation and the neighbor and things of those nature. I'm not sure if you wanted to see those or if it was all right for me to just report that we received those. So that is number 13. That would be affirmed today.
Oh, sorry, missed that. So yes, 13 without objection.
Without objection.
Without objection.
All right.
And then the first affirmation is calendar number 22-194 at 1060 Bolivar Avenue. MTP was granted variances in December of 2022 to erect a 178 residential unit apartment building with retail. The appellant is asking for 6 more months because they haven't completed their full architectural drawings yet.
I think that's still reasonable. So without objection on that board?
Without objection.
Without objection.
And so we haven't seen one of these in a while. This is regarding a case that's scheduled on, I think it's July 3rd. Do I have a note there? Yes, July 3rd. They are unable to make that date and are requesting a postponement. And so if you grant postponement today, we can send out notice to the neighbors that there will not be a public hearing on that case and so on and so
I
forth.
have to abstain from this one, so I don't know how that affects the vote. If I have to abstain from the scheduling of it, or Marion, do you know the answer?
You have,
Voting on a postponement does she need to recuse herself?
yeah.
Okay, then I can
I
vote
think the
on
postponement is fine.
Right, but I will be recusing from the underlying case.
Yeah, so,
So we might wanna
in
keep
that
that
case,
date.
probably better.
Yeah, that
What?
will affect the
That's
date.
what date we picked for the.
Exactly, yeah, so we may want to extend.
Longer.
Give them a lot of,
Yeah,
So maybe 60 days then?
I think so.
Yeah.
So that would be August 28th. It's the end of the month. So hopefully we'll have some in place.
I apologize for not catching that earlier. I looked at everything else and then didn't miss that one small paragraph.
I think that's okay. All right, anything else? Anybody? Last call? All right, I'll take a motion to adjourn.
I motion that we adjourn.
Second.
Second.
All right, we are adjourned.
Were you just visiting with us today?